These are the Real Smart Real Estate chapter review cards for law for all of the chapters. And chapter 1. What is the difference between public law versus private law? And the answer is public law is you versus the state. For example, constitution and the government, tax, constitutional, and criminal law. And then we have private or civil law, you versus your neighbor. An example of that is a breach of contract. Let me read it again. What is the difference between public law versus private law? And the answer is public law is you versus the state. For example, constitution and the government, tax, constitutional and criminal law. And then we have private or civil law, you versus your neighbor, breach of contract. Next question, what are the four courts in the judicial system? And the answer is, we've got the trial courts, or we call them the courts of original jurisdiction. Number 1, small claims court, which is anything $25,000 or less, right? Under $25,000. 2, BC Supreme Court, where the evidence may be reheard from the small claims court. Then we have the appellate courts. Just think of Apple here. 3, BC Court of Appeal. And 4, the Supreme Court of Canada. Let me read it again. What are the four courts in the judicial system? And the answer is the trial courts, or we call them courts of original jurisdiction. Number 1, the small claims court, under 25 grand. And 2, BC Supreme Court, where the evidence may be reheard. Then we have the appellate courts, number 3, the BC Court of Appeal. And then lastly, we have the 4th, the Supreme Court of Canada. Chapter 1, question again. What is the difference between equitable, common, and statute law? What's the difference between equitable, common, and statute law? Now, I'm going to actually read it from the most important, we could say, the most weighty down to the lightest. So, statute law. We have government law, we have constitution. Though this is the top level. All right, statute law, government law, constitution. Then secondly, we have the equitable law. This is equitable law, where they decide cases based on fairness. This is merged with the common law in what we call the Judicature Act. And then we have, thirdly, we have common law. So it's court or judge-based law. Stare decisis means you look at the precedents, look at former cases. All right, so let's read it again. In chapter 1 question, what's the difference between equitable, common, and statute law? So most powerful is statute law, for example, government law, constitution. And then we have number 2, we have equitable law, where you decide cases based on fairness, merged with common law, Judicature Act. Then we have lastly and thirdly, common law, court, judge-based law, stare decisis. We have precedents who look at the former cases. And then another chapter 1 question, what are the 4 methods of enforcing a judgment? 4 methods of enforcing a judgment. Answer, number 1, examination of judgment debtor. You got assets. Examination of judgment debtor, you got assets. Number 2, writ of execution, where the sheriff takes away your assets. 3, land, you got land, judicial sale. 4, garnishing order, they only take a portion of your wages, 30%. So we got examination of judgment debtor, 2, writ of execution, 3, land, and 4, garnishing order. Let me read the question again. Chapter 1 question, what are the 4 methods of enforcing a judgment? Answer, number 1, we got examination of judgment debtor. For example, you got assets. 2, we got writ of execution. Sheriff takes assets. 3, land. You got land, judicial sale. And then 4, garnishing order, only a portion, 30% of the wages. Chapter 1 question, what is the judicial system in BC? What is the suing process? Okay, and the answer is, and there's a pyramid little picture here, caricature on the near the question on this page. Bottom of the pyramid is trial courts, middle is the appellate courts, and then the top of the pyramid is the high court. Okay, so anyways, our question again was, what's the judicial system in BC? Suing process. Number one, you commence an action. So you sue somebody. I don't even know if this is really the way it is here. All I know is you file a notice of civil claim, and then secondly, after that, after filing a notice of civil claim, then there is a response to notice of civil claim. I think response to notice of civil claim. That's where the defendant will put in there, and then. Anyways, then there will be discovery, trial, and judgment process. So let me read that again. What is the judicial system in BC? What's the suing process? So you want to sue somebody, so you commence the action. You would writ of summons, file an appearance, and that's called the notice of civil claim, right? And then you do, so that's part of that's like a summons, right? The notice of civil claim. And as far as I know, that's what somebody's going to come and serve you, right? And then after that, then there's the response to the notice of civil claim. That's in the written pleading. It's a statement of claim, a statement of a defense. That's the third one. And then the fourth one, discovery, trial, and judgment. Okay, Chapter 2 question. What is the purpose of the Real Estate Services Act, the RESA? And the answer is, number one, to protect the public. Number two, establishing the Real Estate Council of BC, RECB, yeah. And third, set the licensing standards. So what's the purpose, three purposes of the Real Estate Services Act, Chapter 2 question. Number one, protect the public. Two, establish the Real Estate Council of BC. And the third is set licensing standards. Chapter 2 question, how is the Real Estate Services Act, the RESA, administered? And the answer is through the Real Estate Council of BC. How is the Real Estate Services Act, the RESA, administered? Through the Real Estate Council of BC. Okay. Chapter 2 question, what is the Real Estate Licensing System? What is the Real Estate Licensing System? Answer, we've got a representative, like a realtor, a licensee. We've got associate broker, that's the old agent. We've got the managing broker who supervises the reps. And then we have the brokerage, like Royal Pacific Realty. Again, what is the Real Estate Licensing System? We've got a representative, a realtor, we got associate broker, an old agent, we got a managing broker, supervises reps, we got a brokerage, ABC Realty. Chapter 2, how does the Real Estate Services Act, RESA, govern licensees? How does the Real Estate Services Act govern licensees? And the answer is through rules and bylaws. Regulations are governed by the lieutenant in council. So how does the Real Estate Services Act, RESA, govern the licensees? Through rules and bylaws, okay? Regulations are governed by lieutenant in council. That's all right. Now, Chapter 2 question, what happens to a licensee if what happens to licensees who breach the Real Estate Services Act, the RESA? What happens to licensees who break regulations in the Real Estate Services Act, the RESA? And the answer is, a hearing is held and possible disciplinary action is taken. A hearing is held and possible disciplinary action is taken. The council can cancel, suspend license, fine a licensee, and order retraining. The council can cancel, suspend license, or fine licensee and or order retraining. Again, Chapter 2 question, what happens to a licensee if he or she breaches the Real Estate Services Act, the RESA? The answer is a hearing is held and possible disciplinary action is taken. A hearing is held and possible disciplinary action is taken. The council can cancel, suspend a license, fine a licensee, or order retraining. Council can, number 1, cancel. Number 2, suspend a license. Number 3, fine a licensee. Or number 4, order retraining. Chapter 2. What is the Real Estate Council, and what do they do? What do they do? All right. Chapter 2. What is the Real Estate Council and what do they do? Answer. The council, A, administers the act. The RESA, right? B, maintains education. Council maintains education. 3, the council protects the public. 4, the council issues, renews, and cancels licenses. So let's do it again. The council administers the act, maintains education, protects the public, and issues and renews, cancels licenses. Remember, the council can cancel. The board can take away your MLS privileges. So let me say it again. Chapter 2 question, what is the Real Estate Council and what do they do? The council, A, administers the act. B, maintains education. C, protects the public. D, issues, renews, and cancels license. Remember, the council can cancel. They can take away your MLS privileges, the Realtor.ca privileges. Chapter 3 question, what does real property consist of? What does real property consist of? And the answer is, real property consists of land and whatever is erected, growing upon, or affixed to the land. Real property consists of land and whatever is erected, growing upon, or affixed to the land. Again, what does real property consist of? Chapter 3 question. Real property consists of land and whatever is erected, growing upon, or affixed to the land. Chapter 3. An estate is an abstract legal concept. What does this mean? What does this mean? And the answer is, there is no tangible or visible existence with an estate in land. It is a concept that gives a person limited rights to use the land. That's called the doctrine of estates. So again, I want to say that answer again. There's no tangible, visible existence with an estate in land. It is a concept that gives someone limited rights to use the land. We call it the doctrine of estates. So again, the question, this chapter 3 question is, an estate is an abstract legal concept. What does this mean? The answer is there's no tangible, visible existence with an estate in land. It is a concept that gives one limited rights to use the land. We call it the doctrine of estates. Chapter 3 question, what is life estate? What is life estate? And the answer is an estate that lasts for the lifetime of the life tenant. It's an estate that lasts for the lifetime of the life tenant. That's a life estate. And here's a quote. There is specifically reserved by the grantor herein the right to reside on, use, and occupy the property herein conveyed for the rest of her natural life. Again, the question, this chapter 3 question, what is a life estate? And the answer is a life estate is an estate that lasts for the lifetime of the life tenant. Chapter 3 question, how is a life estate given or sold, etc.? How is a life estate given or sold, etc.? Answer is, the reversioner holds the fee simple estate and grants a life estate to someone else. The life estate shows as a charge on the title. The reversioner holds the fee simple estate and grants a life estate to someone else. The life estate shows as a charge on title. Again, the question, how is a life estate given? And the answer is, the reversioner holds the fee simple estate and grants a life estate to someone else. So the life estate shows as a charge on title. So if you go to the land title office in New Westminster, where you look it up on online, you can see that on the title of the property, there's a life estate that shows up. So the reversioner holds the fee simple estate and grants a life estate to some other person. So it shows it as a charge on title. Another Chapter 3 question. What is a life estate pour autre vie? Pour autre vie. And the life tenant, life estate pour autre vie is when the life tenant grants or sells her life estate to someone else. This now becomes a life estate pour autre vie, for another life. It's a legal French meaning for another person's life. Bob, of course they spelt it wrong. It should be P-O-U-R for pour, not pure. Pure means pure. Anyways, legal French meaning is for another's life. Bob is given use of the family house for as long as his mother lives. He has possession of the house pour autre vie. Again, the question, Chapter 3 question here is, what is a life estate pour autre vie? And the answer, the life estate pour autre vie is where life tenant grants or sells his life estate to somebody else. This now becomes a life estate pour autre vie, for another life, and this legal French meaning of for another's life. So Jerry is given the use of the family house for as long as his daddy lives, and he has possession of the house. This is pour autre vie. Another Chapter 3 question. What are the 3 common law wastes? What are the 3 common law wastes? Answer, we've got VAP. Voluntary, ameliorating, and permissive. VAP. So this is the 3 common law wastes. Voluntary, ameliorating, and permissive. Okay? Voluntary, VAP. Voluntary, ameliorating, or permissive. Or you can think of very picky and. Voluntary, permissive, ameliorating. And the 3 common law wastes, voluntary means you like what? I forget what it means here. I can't understand this. You do some action. Permissive is like you allow the property to deteriorate. Ameliorating is when you actually do something to help the property. So those are the 3 common law wastes. Chapter 3 question, is there another waste other than the 3 common law wastes? And yes, there is. It's not under common law. It's an equitable waste. It means intentionally destroying property. Now, either you have a mental problem or you are on some kind of medication or taking drugs, or you're intoxicated, but why would anybody go and intentionally destroy somebody else's property? Isn't that a criminal offense? Why would it even be in here? So the Chapter 3 question, is there another waste other than the 3 common law wastes of VAP, voluntary, ameliorating, and permissive? And the answer is equitable waste, intentionally destroying property. Chapter 3 question, what does life without impeachment for waste mean? What does life without impeachment for waste mean? It means life without impeachment for waste means the life tenant is not responsible for the 3 common law wastes of voluntary, ameliorating, and permissive, the VAP. Wow. So love is blind. You allow somebody a life tenant to have this life without impeachment for waste. Okay? It means life tenant is not responsible for 3 common law wastes. And then we even go further than that. If you said Chapter 3 question, what does life without impeachment for waste, including equitable waste, means? Means that life tenant is not responsible for the 3 common law wastes and equitable waste, so they could destroy the property and no action would be taken against them. So it's almost like you're conspiring to let them destroy the property. What does life without impeachment for waste, including equitable waste, mean? It means life tenant not only can do the 3 common law wastes of VAP, voluntary, ameliorating, and permissive, but he or she could destroy the property and there will be no consequences. Amazing. Chapter 3 question, what is the doctrine What's the doctrine of privity of contract? What is the doctrine of privity of contract? Answer, only parties to a contract can enforce the rights to it. Only parties to a contract can enforce the rights to it. What is the doctrine of privity of contract? Only parties to a contract can enforce the rights to that contract. Chapter 3 question, what are the three interests in land that do not amount to estates? What are the three interests in land that don't amount to estates? And we got three, and they're P-R-E. These are less than estates. So we got P, profit à prendre, profit à prendre. We've got restrictive covenants, R, restrictive covenants. Then we got easements, so P-R-E. These are the three interests in land that don't amount to estates. So we've got, these are less than estates, so P-R-E. Profit à prendre. Restrictive covenants, R, restrictive covenants. E, easements. Profit à prendre, restrictive covenants and easements. Chapter 3 question. What are the three basic requirements of an easement? What are the three basic requirements of an easement? Answer, it must be a dominant and servient tenement. Bullet 2, it must benefit the land, not the person. 3, it must be capable of forming the subject matter of a grant. So it must be it must be capable of forming the subject matter of a grant. So we question again, what are the three basic requirements of an easement? A, must be a dominant and servient tenement. B, must benefit the land, not the person. And C, must be capable of forming the subject matter of a grant. For example, identify the boundaries. You got to be able to form the subject matter of a grant. Okay, let me say that one more time. What are the three basic requirements of an easement? Answer, three basic requirements of an easement. Easement must be a dominant and servient tenement. An easement, B, must benefit land, not a person. So it runs with the land, does it not? And C, the easement must be capable of forming the subject matter of a grant. So you grant something to somebody, okay? So these are... we're identifying you, so they would have to identify the boundaries so they could form the subject matter of a grant. Chapter 3 question, what is a restrictive covenant? What is a restrictive covenant? The answer is restrictive, that means it stops or prevents. Covenant, it's a one-way agreement whereby the covenantor is the only party bound by the promise. So this restrictive covenant imposes restrictions on the use of one person's land for the benefit of another piece of land. Okay, so again, the chapter 3 question, what is a restrictive covenant? The answer is a restrictive means stops or prevents. Covenant means a one-way agreement whereby the covenantor is the only party bound by the promise. It imposes restrictions on the use of one person's land for the benefit of another piece of land. Ooh. Can I read that again? Sure you can. You can do whatever you want. Chapter 3 question, what is a restrictive covenant? So restrictive means it stops or prevents. Covenant is a one-way agreement whereby the covenantor is the only party bound by the promise. So imposes restrictions on the other person, restrictive covenants impose restrictions or limits on the use of somebody else's land for the benefit of another piece of land. Okay, chapter 3 question, what are the three requirements for a restrictive covenant? What are the three must-dos for a restrictive covenant? And the answer is number 1, it must be negative. Restrictive covenants must be negative. Okay? They gotta be negative. Negative. Number 2, restrictive covenants feature the covenantee must retain the property, or if the restrictive covenant benefits the land, then the restrictive covenant runs with the land, so with other owners. And 3, the burden of restriction must have been intended to bind the land. It has to bind the land. So the question, so let me read again. Number 1 must be negative. Number 2, covenantee must retain the property, or if the RC benefits the land, then the RC runs with the land, other owners. 3, the burden or restriction must have been intended to bind the land. So again, question, this is a Chapter 3 question. Chapter 3 has a million questions. What are the 3 requirements for a restrictive covenant? 1, must be negative. 2, the covenantee must retain the property, or if the RC benefits the land, then the RC runs with the land. Okay? And then 3, burden of restriction must have been intended to bind the land. Chapter 3 question. What is a profit à prendre? Profit à prendre. And the answer is a right given. The profit à prendre is a right giving access onto somebody else's land, property to harvest the land. For example, fish or hunt. À prendre, French, it means to take, seize in contracts, as in profit à prendre. Again, what is a profit à prendre? And a right, profit à prendre is a right giving access to another person's property to harvest the land. For example, fish or hunt. So apprendre means, well, I know, I speak French, so it means to, profit, same as English, it means benefits, right? And apprendre means to take. So basically it means benefits for the taking, right? So it's fishing or hunting. Chapter 3 question, what is a fixture? What is a chattel? What is a fixture? What is a chattel? Fixture is something that stays with the land. It's screwed in or nailed down. Chattel is something that was for better enjoyment of the chattel itself. What the heck? Can be easily taken down. So fixture is something that stays with the land. Chattel is something you can take away. So again, chapter 3 question, what is a fixture? What is chattel? Fixture is something that stays with the land. It's screwed in, it's nailed down. Chattel is something that you can be easily taken away. It was for enjoyment of the chattel itself, but it's not part of the land. Chapter 3 question, what is a key concept with joint tenancy? I think they're labeling their chapters wrong here, okay? Alright, but anyways, who cares? What is the key concept with joint tenancy? Joint tenancy. And the answer is the right of survivorship. You cannot will your property to heirs. It automatically goes to the survivor in a joint tenancy. Read it again. In a joint tenancy, we got the right of survivorship. That is the unique thing, key concept. You can't will your property to heirs. It automatically goes to the survivor when you die, right? So what is a key concept with joint tenancy? The right of survivorship. You cannot will your property to heirs. It automatically goes to the survivor in a joint tenancy. Another eternal chapter 3 question. What are the 4 unities in joint tenancy? What are the 4 unities in joint tenancy? 1, 2, 3, 4. And the answers are T-tip. We got time, title, interest, possession. Time, title, interest, possession, T-tip. What are the 4 unities in joint tenancy? We've got T-tip, time, title, interest, possession. T-tip, time, title, interest, possession. Chapter 3 question, what is a tenancy in common? What is a tenancy in common? And the answer is, you can will your property to anybody you like. There's only one unity, and that's possession. You can will your property to any human being you like. They got to be alive, of course. Only one unity, that's possession. What is a tenancy in common? You can will your property to anybody you like. There's only one unity, and that is possession. Chapter 4 question. Finally. What is the difference between a void and avoidable deed? What's the difference between a void and avoidable deed? Is something you can avoid? The answer is a void deed has no legal effect. It's dead. It's empty. Avoidable deed, it means you're able to void. That means it gives you the option to void, right? Avoidable deed is you're able to void. You can void the deed. You have the option to void. So again, the question is, what's the difference between a void deed and avoidable deed? What about unavoidable deed? A void deed has no legal effect. A void deed has no legal effect. Avoidable deed gives an option to void. Avoidable deed gives an option to void. Chapter 4 question. What is the Torrens system? Torrens system? And the answer is actual title to the land is registered, not just the documents affecting the title. So we no longer have to search back through history of the deeds to prove ownership. The actual title of the land is registered, not just the documents affecting title. So we no longer have to search back through deeds to prove ownership. So this is the Torrens system. Torrens system, we have actual title land is registered, not just the titles affecting the documents affecting title. We no longer have to search back through deeds to prove ownership. Chapter 4, what does the principle of indefeasibility mean? What does the principle of indefeasibility mean? Answer, it guarantees title to the buyer, that if they have dealt with the registered owner on title and paid fair market value, no one can dispute their ownership. So indefeasibility principle, it guarantees title to the buyer, that if they have dealt with the registered owner on title and paid fair market value, no one can dispute their ownership. There you go. Chapter 4, if the true original owner cannot get his property back due to the principle of indefeasibility, then what can he do? If the original owner cannot get his property back due to the principle of indefeasibility, then what can he do? He can apply to the assurance fund for compensation. He can apply to the assurance fund for compensation. So this is what the owner, if the true original owner can't get his property back due to the principle of indefeasibility, then he can apply to the assurance fund for compensation. Pending litigation, blah, blah, blah. Chapter 4. What is the difference between a caveat and pending litigation? Good question. What is the difference between a caveat and pending litigation? Caveat is a note placed on title by a person claiming an interest in that land and preventing all dealings, etc. For example, transfers, mortgages. So you must renew the caveat every 2 months. And pending litigation is a court action has begun. It stops transfers of mortgage or title. So we've got the question, caveat again, is a note placed on title by a person claiming an interest in that land, prevents all dealings, like transfers, mortgages, must renew it every 2 months. Pending litigation is a court action, has begun, stops all transfers of mortgage on title. Question again, what is the difference between a caveat and pending litigation? We said a caveat, it's a note placed on title. All right, I guess they're both notes placed on title, but a caveat is just simply a note. It's saying that there's an interest in that land and something's going on. It prevents all dealings, transfers, mortgages, and you have to renew the caveat every 2 months. But pending litigation is different. It is a note. It's not for an interest in land. It is that there's a court action, and it stops all transfers of mortgage or title. Okay, caveat, there's not necessarily any court action yet, but pending litigation there is. Chapter 4, does a manufactured home have the same registration system as the Torrens system? Does a manufactured home have the same registration system as the Torrens system? And the answer is no. Manufactured homes are not registered in the Land Title Office, but in a manufactured home registry in Victoria. No, manufactured homes are not registered in the Land Title Office in New Westminster, etc., but in a manufactured home registry in Victoria. Chapter 5 question, in trespass, what are 1, wrongful entering, 2, wrongful remaining, and 3, wrongful placing? What do we got here? Trespass. Wrongful entering, remaining, and placing. So the answer is wrongful entering. You have entered areas of no trespassing. Bad boy, bad girl. 2, wrongful remaining. You were asked to leave, or your stay has, you've hit the limit, but you continue to stay. And 3, wrongful placing. You put something on somebody's property. So let's do it again. 1, these are the trespass. We got wrongful entering. You've gone where it says no trespass. Wrongful remaining, you've stayed too long. Wrongful placing, you stuck something on somebody's property. Chapter 5, question: what are the 3 things that must be proven for trespass? What 3 things must be proven for trespass? And the answer is, number 1, it must be intentional. You meant to do it. It must be intentional. You meant to do it. Number 2, it's a direct act, voluntary. It's a direct act, voluntary. 3, it's actionable per se. No damages need to be proven. Okay? Again, it must be intentional. 2, direct act, voluntary. And 3, actionable per se. No damage needs to be proven. What 3 things must be proven for trespass? Number 1, it must be intentional, meant to do it. 2, direct act, it was voluntary. And 3, it was actionable per se. No damages need to be proven. Yeah, there's a funny sign here. No trespassing. Violators will be shot. Survivors will be shot again. Oh my goodness. What are the remedies to trespass? What are the remedies for trespass? Chapter 5 question. And the answer is diss. They're dissing you. Damages, money. Injunction, stop something. Self-help, gently remove someone. So you're dissing somebody. Oh, damages, injunction, self-help. So again, what are the remedies to trespass? Chapter 5 question. Remedies to trespass. We got diss. You're dissing people. That's the remedy. You can diss them. Damages, money. Damages. Injunction, self-help. Damages, it means money. Injunction, it means you stop something. Self-help, you gently remove somebody. Okay, Chapter 5, what is private versus public nuisance? What is private versus public nuisance? And the answer is private nuisance. That affects the use and enjoyment of an individual's property. That affects the use and enjoyment of an individual's property. For example, bees in my hot tub. Public nuisance affects the safety, comfort of the public, like a large factory emitting toxic waste. Private nuisance, again, is when something hurts my property or my enjoyment of it. Bees in my hot tub. Public nuisance affects like the general public, like a cesspool cloud of toxic poison. So what is private versus public nuisance? Private nuisance is it affects the use and enjoyment of an individual's land, like bees in my hot tub. And then public nuisance, it affects the safety, comfort of the public, like a large factory emitting toxic waste. Chapter 5 question. Do you need to prove damages in trespass and nuisance? Do you need to prove damages in trespass and nuisance? That is a very good question. I wonder what the answer is. And the answer is trespass, no, you don't need to prove damages in trespass and nuisance. Nuisance, yes, you do. Trespass, no. Nuisance, yes. Again, do you need to prove damages in trespass and nuisance? For trespass, no. But for nuisance, yes. Chapter 5 question. If a beekeeper has been running her business for 25 years, you moved in next door and claimed the bees attack you every night you go into the hot tub. Wow, you go every night. Could you sue for nuisance? Okay, again, if a beekeeper has been running her business for 25 years and you moved in next door and claimed that the bees attack you every night you go out to use your hot tub, could you sue for nuisance? The answer is yes. This could be a private nuisance if the bees disturbed the person's use and enjoyment of their property continually. Yes, this could be a private nuisance if the bees disturbed the person's use and enjoyment of their property continually. Again, let's just say, let's make up another scenario. What if somebody played their rock music? They had, I don't know, what if they had rock concerts like every night? for 25 years, and then you claim for nuisance, and then because it's hurting the enjoyment of your property? Maybe. Anyways, Chapter 5, the remedies for nuisance are very similar to trespass. What is the difference? The remedies for nuisance are very similar to trespass, but what's the difference? So here we got the difference. Aid, A-I-D. So we got damages, same as trespass. Injunction, same as trespass. So these two are together. Damages and injunction, same as trespass. But then we got abatement. That's peaceable entry onto somebody's property to stop or prevent a nuisance. So you can do that for nuisance, right? But you can't do it for trespass. Trespass, you can gently remove people. Okay? All right, so we got damages, injunction are same between both, nuisance and trespass. But for nuisance, you can do abatement, which means peaceable entry onto somebody's property to stop or prevent a nuisance. Wow, I'd like to see that. Watch the machine guns jump out. Chapter 5, what is negligence? What is negligence? It's something she wears at night. Honey. Chapter 5, what is negligence? The answer is it's a failure by someone who is considered a skilled expert in his or her field to provide the duty of care as required by law. For example, doctor, lawyer, pilot, realtor, they have all these jobs, they have a fiduciary duty to take care. Fiduciary meaning, it's like the word fidelity, faithful. They've got to be faithful to their duty. So it's a failure by someone who's considered a skilled expert in their field to provide the duty of care required by law, like a doctor, lawyer, pilot, realtor. They have a fiduciary duty. Just wait, that's negligence. What is negligence? Negligence is a failure by somebody who is supposed to be a skilled expert in their field, and they have failed in their duty of care that the law requires them to have. The doctor has failed. Negligent. Lawyer has failed. Negligent. The pilot has failed. Negligent. Uh-oh. Then you might be dead, right? They might have crashed their plane. Or at least you got injured. Realtor, also can be negligent and fail to be faithful in their fiduciary duty. Chapter 5 question. What 3 things do the courts look at to determine negligence? What 3 things do the courts look at to determine negligence? Okay, to determine negligence, number 1, there must have been an untrue statement. There must have been an untrue statement. Number 2, it must have been made negligently. It must have been made negligently. And number 3, a reasonable person would have relied on that statement. Number 3, a reasonable person would have relied on that statement. And yes, there may be a case for negligence. Then, in that case. Question again. We've got what are 3 things the courts look to determine negligence? Number 1, negligence. There must have been an untrue statement. Untrue. Number 2, it must have been made negligently. That means carelessly. 3, a reasonable person would have relied on that statement. Okay? If yes, then there may be a case for negligence. Chapter 5, question. What's the difference between negligent misstatement or deceit and fraudulent misrepresentation? What's the difference between negligent misstatement or deceit and fraudulent misrepresentation? And the answer is negligent misrepresentation. This gives advice or opinion without due care or qualification. Negligent misrepresentation, that means gives advice or opinion without due care or qualification. Fraudulent misrepresentation, it's like a big lie. Fraudulent misrepresentation is a big lie. Ooh, squeeze me. Again, what is the difference between negligent misstatement or deceit and fraudulent misrepresentation? negligent misrepresentation, you give advice or opinion without due care or qualification. That means you're just kind of careless, a little bit lazy. You say, don't worry about it. I'm sure it's fine. It's like you got attitude problem. But if it's fraudulent misrepresentation, then we got Pinocchio with his nose growing because he lied so much, and Jiminy Cricket just standing on the nose. That's a big lie, fraudulent misrepresentation. Chapter 5, what is a tort? What is a tort? Is it like a cake? Below that, a tort? What is a tort? And the answer is, a tort is a civil wrong, such as defamation of character or negligence. Okay, a tort is a civil wrong. It's usually between person to person, a private wrong, such as defamation of character or negligence. So, as far as I know, defamation of character, that means slander. You say, you post things online against other people, say bad things. Chapter 5, what is the Occupiers Liability Act? How may it affect you? What is the Occupiers Liability Act and how may it affect you? And the answer is, the Occupiers Liability Act has it that features an occupier owes a duty of care to see that the premises are reasonably safe for people coming onto the property. This affects realtors at open houses as the occupier is liable. An occupier owes a duty of care to see that the premises are reasonably safe for people coming onto the property. This affects realtors at open houses as the occupier is liable. Again, what is the Occupiers Liability Act and how may it affect you? An occupier owes a duty of care to see that the premises are reasonably safe for people coming on the property. This affects realtors at open houses as the occupier is liable. The occupier.